Welcome to the monthly Truck Stop webinar brought to you by the Motor Carriers Insurance Education Foundation. Truck stops are presented the second Thursday of each month at 2 p.m. Eastern Standard Time. The webinars are open to members of the foundation. These webinars are presented as industry updates for information purposes only and do not qualify for state CE credit. If you're seeking CE credit, we do provide that with the foundation. Just contact our office at our MCIEF.org or call our office or email at trs@mcief.org. If you have any questions, please type them in the chat window. They will be answered as time allows or responded to after the webinar via email. If the questions are generic enough, then we'll also publish the answers to everybody who attended this webinar. If you experience any audio problems, please send us a note in the chat window or call our office at 800-741-4084, and we'll attempt to correct the problem as soon as possible. As we do often, we bring up Bridgette Blitch again as a subject matter. Bridgette, are you there?
I am.
Well, welcome, and we appreciate you spending time here. This recent court case that the Supreme Court ruled concerning arbitration was interesting to me, and I appreciate you spending time to walk through this. These are areas that I don't have a lot of familiarity with, but as we talked earlier, it would impact our insurance and coverages that would be involved, maybe employee practice liability or work comp, these kind of things there. So let's talk about the view, and then we'll take time during the presentation to talk about maybe certain insurance areas here. But I appreciate your information that you put here, and we'll emphasize as we move forward. So let's go ahead, Bridgette.
Absolutely, Tommy. Well, thank you so much for this opportunity, and it's always an honor to present before the members of the Motor Carrier Insurance Education Foundation. So I appreciate that. So let's get started here with the presentation here. And as Tommy mentioned, the importance of this is the relevance of your customers' contracts and the potential liability exposure that may exist in those contracts if they're not being updated by qualified transportation law counsel.
Bridgette,
So,
ma'am,
yes.
I need to ask you, are you talking about customer shipper contract, or are you talking about independent contractors contract, or both?
I'm referencing the agents and their underwriters, their customer contracts. So contracts that are contained within logistics companies, that is brokers, or motor carrier contracts, which would mean independent contractor agreements for owner-operators that are leased onto the operating authority of a motor carrier, or in the case of a broker, we're talking about broker motor carrier agreements. So we're looking at those contracts in the industry that are entered into between different players in the supply chain.
Okay, so all three of the contracts then, they're relevant to the motor carriers we'll deal with. I just want to make sure everybody understands we're talking about all the contracts, where some of you who are listening might only be concerned about the independent contractor agreements, whether you're employee or not, or dealing with that, where others will be concerned about the contracts that your insured signs with their customers and whole harmless agreements and those kind of things. So I just want to make sure everybody understands that we're giving with a broad base of this in any contract our motor carrier will enter into, or our insureds would enter into. Go ahead. I didn't mean to interrupt.
Absolutely.
I just want to clear that up here. Go ahead.
No,
this is information about you, right? Okay. Go ahead.
Yeah. So here's kind of the play that we're going to go through today with respect to the information that I want to share. And what we're talking about here first is going to be the Federal Arbitration Act. And what is it, and why do you care about it as an agent or an underwriter? And then what impact does it have on your customers? And then the two related cases that we're going to talk about is Epic Systems Corporation versus Lewis, as well as New Prime versus Oliveira. And what those court holdings say in relationship to the Federal Arbitration Act. And then we're going to talk about what are contracts of employment. So, Tommy, as you indicated, the big picture here is we're talking about potential risk exposures in contracts and how do we reduce risk of our insureds when they enter into contracts, whether it's an independent contractor agreement or broker motor carrier agreement or some other contract within the supply chain. Then to put it in context, we are going to pull out two specific arbitration statutes, that is state arbitration statutes, and we'll look at Wisconsin and Florida. And those are two statutes that I deal with frequently, and they're just as an example of how arbitration can still be a vital tool for motor carriers and brokers to use when negotiating contracts. Then we're going to talk about some potential solutions for the industry and light of the recent rulings that we're going to talk about, particularly in New Prime versus Oliveira, as how can we continue to enforce arbitration agreements and waivers of class actions.
Bridgette, I want to make a note here. We talk often, and I've been asked often about, can I get a sample contract? Can I get a something from owner operator's contract? And I think the point you're making here is something that I try to share with everybody. We can give overviews of what should be contained in a contract as far as the provisions, the whole arms agreements, and all that, but you cannot deal with a generic one because every state has certain provisions in it. And so when a contract is drafted, then it's going to be subject to certain state laws. And this is a prime example of this, is that you cannot use just a boilerplate without understanding the provisions of the state it's going to be adjudicated under. And I think this is a prime example of that.
That's exactly right, Tommy. And so you have contracts that will contain a choice of law provision. And then if it's, let's say, Florida, then Florida state law will apply. And then you also have contracts that say, well, laws of the United States or federal law will apply. And so those two choice of law provisions are going to have an impact on the operations of the company. And so there is no just simple contract, if you will, that can be distributed and used universally. And we always obviously want to make sure that our insureds are drafting their contracts with qualified counsel that understand the implications of the particular choice of law provisions that they're selecting in their contracts.
Right. I'm sorry. Go ahead. That's good.
Yes. And then the last discussion, and this is one that I've heard in the industry on different programs, is does the ruling from New Prime versus Oliveira affect the independent contractor model at all? And so I just want to take a few minutes to talk about what some of the discussions are in the industry, and just to give a perspective on that question. All right, so let's talk about the Federal Arbitration Act and what it is. It is a federal law that allows parties to put into their contracts the ability to resolve their disputes through binding arbitration. Now, there's a lot of reasons why parties will want to opt for arbitration in the event of a dispute. Oftentimes, parties will want the qualifications of an arbitrator that has experience in resolving matters related to the transportation industry. And so parties can select a forum, for example, whether it's the American Arbitration Association or, for example, the Transportation Lawyers Association Arbitration Dispute Resolution Forum, as a platform for a dispute resolution. And in making this selection, let's say it's with the AAA, the parties have the ability to choose from arbitrators that practice in transportation law or maritime law or specifically commercial dispute. And you can then go further and dictate what rules you would like to apply in your arbitration dispute. So if, for example, let's take the AAA, the American Arbitration Association, you can elect to have your disputes resolved through the commercial arbitration rules. Or if it's a certain amount in controversy, you can have it resolved through an expedited proceeding and just have your dispute resolved through paper submissions.
Bridgette, this is an important point.
Oh, go ahead.
And I think, you know, judges aren't familiar, particularly judges at the state level, much less even the federal level, don't understand everything about transportation. I have been an arbitrator for a number of cases here because I had some expertise of the subject involved in the dispute. And I think this is relevant here, that this gives an advantage for you pick parties who understand the transportation, who will understand the areas that were in the dispute. And plus, it should, in a lot of cases, save time because of the cost of the dispositions and things like that. So those are the two things I see about this. Mainly is that you got people who understand what the dispute's about versus a judge who might not, or even a jury who might not.
And that's exactly right, Tommy. So it gives the parties the ability to choose basically their expert. So when you go into court, you don't know what judge you're going to get assigned. And you don't know necessarily what the qualifications of that judge are going to be in reviewing your dispute. And so I like the predictability, at least as best as you can measure it, with arbitration. And I obviously, as you know, I'm an arbitrator as well, and I've had the pleasure of serving with some fantastic fellow arbitrators, both who have been retired judges, as well as also professionals in the transportation industry. And collectively, I think the wisdom that you can get either from just a one panel or three panel arbitration can lead to a swift resolution of a dispute. And it can also provide more expedited rulings on dispositive issues, and give the parties the ability to control how they want to proceed with the actual process. Something that parties may not know is there's first a preliminary hearing that gets scheduled where the parties have the ability to set their deadlines, set the type of discovery they want to engage, and set dates for future status conferences. So it really does give the parties a really good ability to control how they want to proceed, which in turn can also help keep costs down and more expeditiously get dispositive issues before the panel for potential rulings.
Yes, ma'am. That's what you did great. Go ahead.
So that's just kind of the overview of arbitration and why parties may opt to pursue that as a form of dispute resolution. Now, there are exceptions under the Federal Arbitration Act. Again, we're talking about federal law that says that although the parties have the ability to enforce private arbitration agreements, of course, there's always exceptions to every rule. And this one is, but nothing herein contained shall apply to contracts of employment of seamen, railroad employees, or of any other class of workers engaged in foreign or interstate commerce. And so what we're going to talk about here in a little bit more detail is the class of workers engaged in foreign or interstate commerce. All right. So we talked a little bit about what the benefits of arbitration are. And here's just the list to review again. One thing is, with your arbitration provisions in your contracts, you want to always make sure that you put in there as much certainty as possible. So if you are going to elect arbitration, decide what location you're going to have that proceeding in. For example, if you want to have it in Orange County or Orlando, make sure to note that in your arbitration agreement. Also, you want to make sure you note which parties are going to be responsible for the cost of the arbitration, because arbitrators are paid a fee. Even in expedited proceedings, it's a nominal fee. It can be a flat fee, but you do want to dictate as to whether the parties are going to share that cost or if it's going to be shifted to the non-prevailing party. And then also whether you want the arbitrator to award prevailing party attorney's fees as part of any dispute. And then the last piece is, obviously, when you go through this process, or your brokers or motor carriers go through this arbitration process, they want that award to be binding, right? So you don't want to just go through this process not to be able to enforce a arbitration award. So you always would put in there to ensure that it's binding and not subject to appeal. All right. So we've talked about the Federal Arbitration Act. We've talked about the benefits of arbitration. Let's get into something that's specific with respect to dispute resolutions and why it's important to have a well-drafted contract. And the case of Epic Systems highlights that point for us. Now, that case wasn't specific to the transportation law industry, but what it did focus on was the validity of employment contracts in which employees gave up their right to collective litigation, or basically class action. And so what that court determined was that these arbitration agreements between employers and employees that called for individualized proceedings were to be enforced as written. So in other words, that if the employees gave up their right to proceed with litigation, they could be held to arbitrate their disputes. And this specifically, there was nothing in the federal law that expressed or disapproval of arbitration or class action procedures. And what that particular case was talking about was the NLRA. And the employees in that particular situation were trying to enforce the Fair Labor Standards Act and the ability to proceed through court proceedings rather than through binding arbitration. And so what the court ultimately held in that case is parties can, and including specifically contracts between employers and employees, can opt to have their disputes resolved through arbitration. And therefore, the takeaway from that case is, in your arbitration provisions in your clients, and that is your brokers, your motor carriers, transportation contracts, you want to make sure, number one, that you have a provision to arbitrate, but also that any dispute that is brought between the parties is brought in that person's individual capacity and not as part of a class or class action. Because as we've seen in the industry, certainly owner-operators or drivers will put their position, that is their classification as an employee or an independent contractor, at issue, and they will attempt to avoid arbitration and instead initiate litigation in a federal forum to collect, let's say, back wages or overtime wages under the FLSA. And then they will attempt to certify a class and bring other fellow drivers or owner-operators into that class to get back paid wages or overtime wages. And so if we can harness in our contracts a provision that says drivers are only able to bring proceedings in their individual capacity, and that all disputes are going to be subject to binding arbitration, we are, in effect, helping our insurers or our clients reduce their risk of liability exposures for potential employment claims. So Epic Systems was the case that basically affirmed the industry's ability to have arbitration agreements, that those arbitration agreements were going to be enforced, and that there is a policy in favor of enforcing such arbitration agreements in according to their terms. The court also indicated, and although this was specific to the NLRA, that did not contain any indication that it was meant to displace or override the Federal Arbitration Act. So in other words, the FAA stands. So again, one reason we want to be aware of what is in our insureds or our clients' contracts is to ensure that we have class action waivers and that we have ability to arbitrate our disputes. Now let's fast forward to January of this year and talk about the New Prime versus Alvaria case. And this was a case that I think a lot of us in the Transportation Lawyers Association and folks practicing transportation law were waiting to see the outcome of this case. Now, it's a progression, if you will, from EPIC systems, because in EPIC we knew that the parties could agree to have employment disputes resolved through arbitration, again, not in the context of transportation law or interstate commerce, but that employer and employee disputes could be resolved through binding arbitration and class action waivers were enforceable. Now we're going to take the second piece of this and say, does that same rationale apply to workers engaged in interstate commerce? Remember, that was the provision that we had looked at a few slides ago. So in New Prime, the driver claimed that he was an employee rather than an independent contractor, and that he had leased on to the operating authority of New Prime, and pursuant to that contract, all disputes were to be resolved through arbitration. And there was a provision that said that the arbitrator would decide whether the arbitrator had the authority to hear the dispute under the arbitration agreement. Just a quick side note on this. Whenever we get cases through, let's say, the American Arbitration Association or the Transportation Lawyers Association, those associations have to ensure that they have jurisdiction over the dispute. All right, that it's clear that the parties have said, yes, we want AAA to review this dispute, and therefore, once the AAA confirms in the contract, okay, yes, the parties have agreed, AAA is authorized to resolve all disputes, then it'll go to the arbitrator. Now, of course, the arbitrator also has the ability to ensure that they have the right to determine a dispute, because the last thing they want is to have an award overturned, right? So you want to make sure that the parties are in agreement that this dispute is ultimately going to be enforceable. So that would be the two-part test in New Prime, is looking at whether or not the driver had the ability to bring his action in court, or whether he was going to be subject to arbitration, and then whether the arbitrator had the right to determine if they had the ability to review the dispute. So there's the two issues. And in this case, although the parties, at least on paper, said Mr. Oliveira isn't an employee, the party contract labeled him as an independent contractor. And in that dispute, he argued that New Prime denied him lawful wages. And the company may call its drivers independent contractor, but of course, as we've heard this argument made in other cases, Mr. Oliveira alleged in reality they treat him as an employee. Okay, so he's putting his status as an independent contractor at issue.
Bridgette, Bridgette, and so what we're discussing here now is not if he was or was not an employment contractor employee. What we're discussing here is when a dispute rises like that, how can it be resolved short of, and what you're saying is that, and the Supreme Court, and this is U.S. Supreme Court, by the way, gives us guidelines about what the contract has to keep it out of court and have it for arbitration. Is that the bottom line to this dispute? Exactly. Okay. Yes, that's it. So we have a driver.
he enters into an independent contractor agreement to lease onto the operating authority of a motor carrier. The contract says all disputes will be resolved through binding arbitration. But when that employment dispute comes up and the driver puts his status at issue, he says, I don't have to arbitrate. Number one, I'm an employee, and therefore I can bring my action under FLSA because of the exception to the enforceability of the Federal Arbitration Act, which is workers engaged in interstate commerce. Well, for the purposes of this opinion, the issue became, okay, even if we assume that he's an independent contractor, are workers engaged in interstate commerce only employees, meaning that only employee drivers are able to bring their disputes into court, or does it apply to independent contractor drivers as well? So the issue that the United States Supreme Court noted was, does the FAA apply in terms of allowing an independent contractor to come under the provisions of that statute and have their dispute subject to arbitration versus reviewed in a federal court proceeding?
Bridgette, you said the independent contractor, but that would be the motor carrier would want the independent contractor to do this, not necessarily the independent contractor, right? Is that what you?
Yeah, I mean, there may be occasions where an independent contractor could want their dispute resolved by arbitration, but what we find most often is that plaintiff lawyers that will contact these drivers and take on their case on a contingency fee basis because of the prevailing the party and statutory right to attorney's fees under the FLSA.
Okay, that's what I'll say. The motor carrier wanted it to be arbitrated, and the employee in this case did not. Olivia did not want that. All right, go ahead. I'm okay.
Yes, that's right. So the court says, what does the term of contract of employment mean? And we have Justice Gorsuch delivering the opinion of this case going through, I think, which was a very good analysis.
We need to move to the next slide. Yeah. Okay.
Oh. Of the opinion.
Right. Yeah. Oh.
Okay. So here we said Okay. So here we've talked about Mr. Oliveria agreed to assume for the purposes of appeal only that his contract established an independent contractor relationship, right? And here we have the Supreme Court evaluating the meaning of the terms based on their ordinary meaning at the time Congress enacted the statute. So we have the court going through an analysis of saying, all right, what does the workers engaged in interstate commerce mean at the time that the statute was enacted, which was in 1925. So here we are, almost 100 years later, and the Supreme Court is going back to say, all right, let's look at what the definition of worker meant in 1925 and what was Congress's intent in 1925. And so they go back and they look at Black Law Dictionary, and they look at the definition of a worker as between a master and a servant. But then they also go through and they actually look at the definition back in a New English Dictionary on historical principles in 1891 and how that defines employment. They also go back to a dictionary in 1914. They look at references in 1960, 1933. So it's interesting to watch their analysis as they look of, okay, well, did a worker mean both an employee and an independent contractor in 1925? And ultimately, the conclusion that they came to is yes. Most people would have understood that exception would include not only employers and employees, but also agreements to work, including independent contractors. And so that's the significance of this case, is that now you have the Federal Arbitration Act will not govern disputes entered into between workers, and that means both employees as well as independent contractors, engaged in interstate commerce. And it's not just unique to drivers, right? You could have a situation between a broker and a motor carrier that has an arbitration provision in it. And if that motor carrier were to challenge the enforceability of arbitration, they could say, if the choice of law was federal law, that New Prime versus Alvaria will serve to override the enforceability of that arbitration provision, such that all disputes would have to be subject to state proceedings.
But you could elect then to have it, and what you're saying here is elect to have it interpreted not at the federal level, but the state level, and then understand each state law then. Is that what you're thinking?
Right. So,
or am I getting ahead of you?
You're good. So, so what we have to determine for our clients, for our insureds, is, do they have those provisions? Remember, I mentioned in the beginning that there are some contracts out there where, and I've seen this, where the client elects to have federal law apply to resolve their dispute. And if it's not clear that the particular state law will apply, then I think that this case will serve to basically take away the jurisdiction of either the federal, under the Federal Arbitration Act, to have AAA or TLA or any one of these associations review and make a determination on their dispute. So as you mentioned, then what we need to look at is, all right, what about arbitration laws under the individual state laws? Because New Prime did not have any discussion related to the enforceability of arbitration laws as enacted by state law. So here's an example of the Wisconsin arbitration statute. Now, before I go into this particular statute, let me make a note that prior to New Prime, a lot of this dispute that arose regarding the enforceability of an arbitration provision was whether or not a party was an employee or an independent contractor. So, for example, motor carriers would make the argument that a driver was an independent contractor, and therefore he was subject to binding arbitration under the FAA and could not bring his or her case in court. On the other side, the employee or the driver would claim that they are an employee, and therefore they were a worker engaged in interstate commerce, and the exception under the Federal Arbitration Act would apply. And so this underlying dispute would continue until there was a determination first of whether that person was an employee or an independent contractor. Now, because of the New Prime, we know that in the context of federal law, that determination doesn't apply, regardless of whether the person was an independent contractor or an employee. Now we have to look at, what does the state arbitration statutes dictate as it relates to the enforceability of arbitration agreements. So in Wisconsin, it's the parties still have obviously the ability to contract to settle dispute by arbitration. But now we have in here a similar provision to what we saw in the FAA, where there's an exception that it says that this chapter does not apply to contracts between employers and employees. So if we choose Wisconsin as our choice of law provision, there is still the possibility that the party will put their status at issue. So if you have an independent contractor driver, they're going to argue, like Oliveria did initially, is that, well, I'm not an independent contractor, I'm an employee, therefore I can pursue my right to wages under FLSA. And you're going to see that, or you will likely see that same argument become an issue under the Wisconsin arbitration statute because of that exception. So that doesn't mean, though, obviously, if a determination is made that your driver was an independent contractor and not an employee, that that the Wisconsin arbitration statute will then allow the parties to arbitrate their dispute. So there was a case, and this is a couple years ago, but I think it just kind of gives an example of the courts in Wisconsin recognizing the parties' ability to arbitrate disputes. And in that case, there was an employee that had been terminated by his employer, and he had filed a complaint with the Wisconsin Equal Rights Division and the EEOC for benefits, and claiming that he had been discriminated against under the ADEA. And so in that case, he did have a contract to arbitrate his dispute. And so the court ultimately, and again, this is not in the context of a driver or worker engaging in interstate commerce, but rather an employee that had contracted with his employer to resolve disputes under an arbitration agreement. And the court said that in this case, in the agreement, that the employer, that the individual claiming that he had a right to pursue court action, said that his agreement provided that he was an independent contractor, and that ultimately he could pursue, or that the contract that he entered into required him to resolve his disputes in arbitration. Now, the issue is that this little piece here, which says where the FAA is and again, that's the Federal Arbitration Act, is in conflict with the state arbitration statutes, such as the WAA, the FAA controls. So here's where, on the surface of the statute, we see, okay, that there's an exception to the application of the Wisconsin arbitration provision, which is that employment contracts are not enforceable under the Wisconsin arbitration provision. But if you're able to establish your position as an independent contractor, then that exception would no longer apply. And what you have to make sure of is that basically the supremacy clause in this provision doesn't serve to override the enforceability of the arbitration provision. So this is where, even with the application of the state law of Wisconsin, we're going to see some disputes that are going to come about, most likely with the application of even state law applying in light of new crimes. So, Tommy, to go back to what you're saying, is there a basic template that a contract that you can give to a motor carrier or to a broker? And this just muddies the water, right? So unfortunately, is what
you're reading the statute, then you're reading the court interpretation of it, which is what I've always said, that when you have a contract, you don't really know what it means until the court tells you what you're supposed to mean. So this is what we're talking about here. But you need to. All right, let's look at the Florida then and see what the difference it would make. By the way, this is an insurance company. I thought this was unusual also in this particular dispute. So go ahead.
Yeah.
All right. This is what you read.
No. So, but I just have to bring that up because I know the industry would love the simplicity, and I hear it all the time. I want short contracts. I want simple contracts. Can't you just give me something that just, and rubber stamp it? And boy, that would sure make things a whole lot easier in the industry. But unfortunately, there isn't that easy way or easy road to go.
Bridgette,
so
and
here we are.
this is the point I want to make, and for you who have been to some of my recent classes, talking about, again, a whole different subject of the anti-indemnification agreements in certain states, as the states say they're not enforceable. One of the things that we overlook a lot when we read contracts is the state law it's going to be interpreted under. And it's not where it's signed, it's not where the parties work, it's not where the parties live, it's where whatever that contract says, the state law will prevail, or in this case, the federal law will prevail. So a lot of the times when we look at contracts, we look at all the provisions in it, but we don't look at what the state law interpretation is going to be. So that's a take home for this.
Right, exactly. So you have to be aware of what the laws are in each individual state and how it could impact the enforceability of the provisions that you drafted. Whether you're seeking to have another party indemnify you for your own acts of negligence, for example, and the anti-indemnification statutes may not allow that. Right. Or if you're looking to have an arbitration provision be enforceable, your state statute may not allow that. It's going to be dependent upon a resolution of other issues, such as the status of a person and whether they're an employee or an independent contractor. So let's take a look at Florida as another example. And one thing about Wisconsin, unfortunately, is that it surprisingly is not the best state for employers. There was a recent shift in the justices on the Wisconsin Supreme Court, and there's been some opinions that have come out in Wisconsin, unfortunately, that have hindered, I'll say this, in a motor carrier or a broker's ability to enforce non-competition clauses. And so we're seeing a little bit more of a struggle to protect the proprietary information that our clients or our insurers are developing, and obviously then challenges regarding the enforceability of arbitration contracts, as we've seen here based on the arbitration statute. Now, Florida, however, is a much better venue for not only a company's ability to enforce non-competition, non-solicitation agreements, but also to uphold the status of an individual as an independent contractor. And one of the things that we have in the statutes, for example, under Chapter 440, under the Workers' Compensation Code, is we have the ability of drivers to be deemed an independent contractor because they're an owner-operator, that is, they actually own the equipment, or because they meet a balancing test under the provisions of Chapter 440. And there's two tests that a person can fall under in order to establish an independent contractor relationship. So it's a really good location for companies that are doing business in Florida to operate under the independent contractor model. Again, if they actually have the right contracts in place and they have their operations truly reflecting an independent contractor relationship. So again, that goes hand in hand with what are the liability exposures we're talking about here. Why is this discussion important and relevant for your insureds? It's because you need to know how they're operating. Are they operating both an employee and an independent contractor model? If so, do their operations actually reflect that? Are their contracts consistent with their operations? And do their contracts take sufficient measure to control their risk, such as through the enforcement of an arbitration provision? So my title here is it's a prime time to update your contracts. As a best practice, I say every year your insurers should be getting with their qualified counsel to review their contracts for updates in the law, such as what we just saw with New Prime, to ensure that there isn't some provision in there that's going to be challenged in the event of dispute. And while things may be great today, tomorrow, and the stock market may be up, in a couple of days from now, maybe you're going to get that claim, you're going to get that notice of a lawsuit, and you're going to wish you had revised your contract. So it's always important, and I know a lot of agents and underwriters sound like a broken record sometimes, but don't give up. Continue to impress upon your clients why these provisions really do matter and why they need to be working with somebody in the industry that is aware of the updates in these laws. So getting back to the Florida arbitration statute, what I like here is we don't have that exception for the enforceability of arbitration agreements dependent upon what a status of an employer or an employee relationship or an independent contractor relationship. Instead, there's 3 elements to consider on ruling on a motion to compel arbitration, and that's: does a valid written agreement to arbitrate exist? Is the issue an arbitratable issue? And whether the parties waive the right to arbitration. And so that's pretty simple. I mean, we're not dealing with classification issues. We're not looking at supremacy clause issues. We're looking at, did you have a clear and concise contract? Was it clear that the parties, let's say, elected to have their dispute resolved through binding arbitration through the American Arbitration Association? Was an arbitratable issue, and did the parties do anything to subsequently waive that right? So when we talk about simplicity, I like simplicity, and we get it in the Florida statute. So what's the takeaway here? Now, for the lawyers that are drafting these contracts, or for the folks out there that are reading these contracts and you're looking at these arbitration provisions, look to see, are they specifically incorporating the Federal Arbitration Act in their contract? If so, then you need to say, look, you need to take this to Qualified Transportation Law Council to have your contract looked at and potentially redrafted in light of this new prime case. Then if the federal law does not apply, but state law does, the parties should be looking at, okay, are we dealing this with a state like Wisconsin where we may need to be more careful in our drafting in light of new prime? Or are we dealing in a situation where we have Florida, where we just need to make sure we have a clear and concise contract and agreement to arbitrate? And then we want to make sure we've got other issues addressed in that clause as well, like our venue selection. And keep in mind, one thing is that just because a party resides, let's say, in Wisconsin, doesn't mean that they have to have Wisconsin law apply. Maybe they want Florida law apply because of the favorable provision in their contract regarding the enforceability of arbitration provisions. So instead, perhaps maybe a motor carrier would opt to have, a venue that they would have the AAA hear the dispute and sit on the dispute in Milwaukee, but for that arbitrator actually reviewing the enforceability of the arbitration provision under Florida law, which has a favorable arbitration clause. So a lot of times the parties get stuck on the fact, well, I'm here in Wisconsin, and therefore Wisconsin law should apply. No, you don't have to choose that. You have the contract, you have the freedom of contract.
Right. It's whatever the contract says. That's the point I was making here. I've had one where it was in North Carolina, the accident, and Florida was going to determine North Carolina law. And so that's what the takeaway here is, or the thing I mentioned earlier, Bridgette, is that you look at every contract says what law is going to be interpreted under, and that is the important part of this, not where it's signed and where the parties live or where the parties have business necessarily.
Precisely. Yes. So, again, all good reasons to think about. Don't just assume that your contract is well drafted or that you've got a choice of law provision that you're bound to the place where you have your principal place of business, or you're bound to the place where you incorporated your company. There may be a better option for you. And then, of course, going back to EPIC still stands. EPIC's still good law. So we want to make sure that to the extent that we have issues where potential class actions could be brought, whether it's from owner-operators or from motor carriers, that we have actions brought in a party's individual capacity and not as part of a class. Okay, so here's my favorite question that I've been hearing in the industry. And it's, okay, well, how does this new prime case affect the independent contractor model? There's certainly those organizations out there that are saying, well, this is a challenge to the independent contractor model in itself. And of course, we know that there is always going to be the attack on the independent contractor model. I mean, this goes back many years ago, before President Obama became when he was Senator Obama, and he had a bill to challenge what was the Section 530 relief under the IRS code. And so there's always going to be those laws and those rulings that are out there trying to attack the independent contractor model. But I don't think, in the way that this case is, the new prime case has been drafted, challenges the independent contractor model. The determination of whether a person is an independent contractor or employee is going to be governed based on the law that applies. So if it's in a workers' compensation claim in Florida, then Section 440 of the Florida statutes is going to govern the judge of compensation claims determination of whether a person's an independent contractor or employee. Or if it's an FLSA claim or an unemployment compensation claim, you're going to have your dispute reviewed based on the law applicable to that particular issue. You're going to have in contexts where there's audits and there's issues regarding whether a driver is an employee or an independent contractor, you're going to have the IRS looking at a different set of rules and factors to make a determination of whether or not an employee driver is an independent contractor or not. And so the issue here is that the Supreme Court looked at, again, what was a worker engaged in interstate commerce, and what did that term mean in 1925? And in reviewing the intent of Congress, was it their intention that worker meant employee only, or both an employee and an independent contractor? And the Supreme Court, as I indicated, ultimately came down and said a worker could mean either an employee or an independent contractor. And going through the legislative history and the definitions at the time of its enactment, that was the ruling. And even Justice Ginsburg, in her concurring opinion, said it's appropriate because their job, the U.S. Supreme Court, is to determine what the law states based on the statute's ordinary and plain meaning and what Congress' intention was at the time of the enactment. Now, if Congress doesn't like the ruling of the Supreme Court, they could always come back and they could make an amendment to the Federal Arbitration Act. So Congress has the ability to do that. But for right now,
I'm holding my tongue about the Congress today making ability to do that. But I'll be quiet about that. We need to get finished here. That's a whole different subject, Bridgette. But go ahead. That's
right. So everybody exercise their right to vote. But the Congress has that ability. But for right now, the law as it stands is that workers engaged in interstate commerce can mean both employees or independent contractors. And one last thing is, that opinion, New Prime versus Alveria, again, it was looking at a narrow issue. It didn't discuss business-to-business transactions. And so I'm sure we're going to see a lot of cases distinguishing that opinion from transactions where you do have a company versus, let's say, a broker corporation versus a motor carrier corporation challenging the enforceability of a contract. And then in that case, I think you can distinguish and say, well, New Prime concerned an individual. It didn't concern a company challenging the enforceability of an arbitration provision with New Prime.
Wow. Well, Bridgette, I really appreciate you walking through this. And for you who had your head swimming this thing, just realize the complications complications that she's bringing up and the importance to not only understand the FMCSA requirements for contracts and transfer, which is, as I've always said, it's got to be 5 or 7 pages long to be relevant, but also you need to go to a lawyer who knows the FMCSA, but also the local jurisdictions to draft these various contracts. And I think that's the take home here on this, Bridgette, don't you?
Oh, absolutely. So be aware of what contracts your insured, your clients have, right? And so often, unfortunately, I know that the contract is the last thing to be read. It's the first thing to be signed, so that revenue comes through the door. But it's not worth it. That could be, unfortunately, the snag that causes the company to lose the revenue. So once you understand that it's worth the time and investment to have qualified counsel look over these contracts to make sure that you are preserving and protecting your bottom line,
right,
and protecting your company, then you can look at it with a different set of lens and realize that the money you invest in having well-drafted contracts is going to be worth the effort.
Bridgette, always thank you for your time and expertise and the legal area to make it simpler, even though something like this today is not totally simple, but things that we need to be aware of so we, the insurance providers, can take care or know what our insured's needs and help them stay out of trouble by looking at these things before things happen. But we appreciate that. And for information about the Motor Carriers Insurance Education offering, you can contact our office. And with that, Bridgette, thank you. And everybody else, we'll see you next month.
Thank you so much, Tommy. Take care.